proceedings in the lower court, so that now the court can be able to determine the appeal. Yes.
That's what you're hearing.
Yes.
Yes.
Yeah.
Shall I then begin, my Lord? Yes, my Lord, the application by way of notice of motion is for stay of proceedings before the subordinate court, that is criminal case number 32 of 2018, in which the applicant appelled 32 of 2018, in which the appellant applicant has been charged together with 10 other accused persons. The notice of motion is supported by an affidavit, short affidavit, and we rely on the affidavit. And attached to the affidavit are the proceedings and pleadings filed in the subordinate court together with the charge sheet. My Lord, the charge sheet is found from at the end of the affidavit attached to the motion. From page 1 is the charge sheet. And the charge sheet has several counts as against the applicant and other accused persons. In total, there are 35 counts. My Lord, our grounds in the appeal, and which we discussed in the subordinate court, revolve around 3 issues. One was the question of a defective charge. That was in relation to count 1, charge of conspiracy. And the accused person had 3 counts. One, the charge of conspiracy, which was count number 1, and count number 2 and 3, which were relating to offenses, both of them, on dealing with suspect property, contrary to the section 47(1) of the Anti-Corruption and Economic Crimes Act. Now, the second ground was that the charge is overloaded, 35 counts. In one charge. And the third issue was the issue of misjoinder, for which we sought severance, so that the applicant should be charged separately as against the other accused persons. Now, on account of the charges which are overloaded, the charge speaks for itself, 35 counts, involving more than 11 accused persons, each with different counsels. No, I'm saying there are 11 accused persons and 35 counts. Out of those 35 counts, the applicant is confronted with only 3 counts. The hearing of the case has been set for Monday to Friday of next week, Monday, which is the 6th to the 10th of May. There's a short break from 20th of May, up to the 20th of May. And from 28th of May, the case goes on until October. There may be a break of just 1 week during that entire period. Your Honor, in relation to the first accused, 3 counts, only about 4 witnesses who are going to adduce evidence against him. So it is our position that the overloading of the charge is oppressive because the accused person is going to sit in that court for nearly 4 or 5 months. Basically as a passenger. And in some of those charges, there are matters to relate to taxation and lawful failure to pay tax as against some of the accused persons, which really has nothing to do with the first accused. Even in terms of judicial time, just on that account, it is important that that issue of overloading the charge be looked at. And in our list of authorities, which, my Lord, you're going to deal with, you're going to have time to read. I don't need to go through the authorities which are with you. And then on the other issue is misjoinder. Yeah. My Lord, if you look at the charges in relation to the accused person, they are supposed to have taken place sometime in August 2014, specifically 29th of August 2014 to 11th September 2014. If you look at the other charges as against the other accused persons, the transactions or the offense are purportedly committed on different dates. Over a period of nearly a decade. And on that account, Your Honor, we are saying there's misjoinder. And the accused person should answer to the two counts, count 2 and 3, separately on account of those 2 counts. And if it is determined that there are any other transactions that took place at the same time, then those charges could be valid. But, my Lord, I invite you to look at each and every count, and you find that they could not have arisen from the same transaction. The last issue is on the defective charge. Your Honor, there's a decision that you rendered recently, which we have provided, the case of Michael Kamau, which was Constitutional Petition number 22 of 2018. And whereas, my Lord, I cannot be in a position to completely deal comprehensively and effectively with the issue of the defective charge, But your finding in that case which is found on page 60, 68 and 69, and more particularly paragraph 105. You emphasize the need to have a charge that is unambiguous, that has specificity, and must contain sufficient details to enable an accused person to answer to the charge. And Your Honor proceeded to quash a similar charge of conspiracy in that particular case. So, my Lord, we are inviting you to give us an opportunity.
Do you really want to 60 pages or you